Hello everyone, welcome back to my second presentation. My name is M.Rizki Kurniawan, and today I'm going to explain the topic, Business Entity and AIDS, as part of our second meeting in the business law course at Technocrat University of Indonesia. In the business world, understanding the different forms of business entities is very important. Why? Because every business entity has different legal characteristics, different responsibilities, and different ways of operating. First, let's start with the general definition of a business entity. A business entity is any organization that conducts activities in the economic sector with the main purpose of gaining profit or income. Business entities operate continuously, openly, and permanently, and they are proven by financial records or bookkeeping activities. In Indonesia, we recognize several forms of business entities such as civil partnerships, firms, limited partnerships, limited liability companies, cooperatives, and even state-owned enterprises. One of the most common and simplest forms of business entity is the civil partnership. A civil partnership is formed based on an agreement between two or more people who agree to contribute something valuable to the business, whether it is money, goods, or labor, with the aim of sharing the profits together. This type of partnership is quite flexible and easy to establish because it relies only on mutual agreement. However, the responsibilities of the partners are usually unlimited, meaning that if the partnership faces debts, all partners are responsible using their personal assets. Moving on, we have the firm, or what we often call firma in Indonesia. A firm is actually a more formal version of a civil partnership, and it operates under a joint name. Members of a firm are called partners, and they are actively involved in running the business. The main characteristics include running a business together under a joint name, and the partners share responsibility both individually and collectively. To establish a firm, there must be a written agreement known as the Deed of Establishment. This deed is registered officially and must be announced publicly. The next type is limited partnership, or Commandateur Vennootschap, CV. This is a popular form of business entity in Indonesia, especially for small and medium enterprises. A CV has two types of partners. The first is the general or active partner, who is responsible for managing the company and has unlimited liability. The second is the limited or passive partner, who only invests capital but does not participate in daily management, and whose liability is limited to the amount of capital invested. When we compare firms and limited partnerships, we can see several differences. A firm usually consists of partners who have equal responsibility, while a limited partnership clearly separates the roles. The formation of a firm is regulated in the commercial code, while a CV is not strictly regulated in the same detail. In case of bankruptcy, in a firm, all partners are affected. Now let's discuss limited liability companies, or PT. According to Indonesian law No. 1 of 1995, a PT is a legal entity established based on an agreement and carries out business activities with authorized capital divided into shares. The process of establishing a PT includes several steps: creating a written agreement, preparing the deed of establishment, obtaining ratification from the Minister of Justice, registering the company, and announcing it in the State Gazette. The capital structure of a PT is clearly regulated. The minimum capital is set, and there are specific rules about how much must be paid up front. Shares can have different classes, and there are protections for minority shareholders. A PT can be either closed or open. A closed PT usually involves ownership by a small group or family members. An open PT offers its shares to the public through the stock exchange and must use the term TBK after its name. The advantage of establishing a PT is that it offers legal protection through its legal entity status. It also allows easier mobilization of funds because the company can issue shares to the public. Another important form of business entity is the cooperative. According to Law No. 25 of 1992, a cooperative is a business entity that combines people, physical and non-physical assets, information and technology, operating based on economic rules and principles. A cooperative is not only profit-oriented but also benefit-oriented. Its main goal is to improve the welfare of its members and the surrounding community. Cooperatives emphasize mutual help and are guided by principles of voluntarism, democracy, and fairness. Members own and use the cooperative's services and also contribute to its capital through savings. Any profits made are usually returned to the members or reinvested to improve services. To summarize, there are various forms of business entities in Indonesia, each with its own legal structure, responsibility, and purpose. Civil partnerships and firms rely on close relationships and shared responsibility. Understanding these forms of business entities helps entrepreneurs choose the most suitable structure for their business activities. It also helps in avoiding legal issues and managing risks better. Thank you very much for watching and listening to my presentation. I hope this explanation has helped you understand more clearly about business entities and how they function. See you again in the next video. Goodbye.